are not yet ready, so we can ask that we suspend those proceedings and just get right into the presentation. So I believe we would have the Ministry of Tourism here. Can you just introduce yourself, please?
Good afternoon, everyone. My name is Priscilla Chambers. I'm the Director of Human Resource Management and Development at the Ministry of Tourism.
Welcome.
Good afternoon. My name is Shirley Haynes, Legal Officer for the Ministry of Tourism.
All right. Well, very warm welcome. So, right into your presentation.
Okay, the general...
Before you begin, and, can I just recommit to apologies for absence? You have no apologies? I would have from Senator Longmore, who is unable to make it.
Mrs. Voss.
Mrs.?
Voss. Mrs. Anne-Marie Voss.
Mrs.?
Voss.
Oh, and Member Anne-Marie Vaz, for the record.
Okay, the Ministry of Tourism commends the Ministry of Culture, Gender, Entertainment and Sport, as well as other interest groups for their sustained effort in advocating for the enactment of legislation that makes provision for the prevention of sexual harassment in Jamaica, having recognized that currently there is no specific legislation in Jamaica that covers the subject in its entirety. After reviewing the bill, the ministry deliberated on the sexual harassment bill and has made the following specific comments. Generally, the definition section of the bill brought about clarity and made it easy for the layman to understand. However, we felt that the following terms would require further consideration. And the first term is that of sexual advance, which is found in Clause 2A of the document. While the definition seeks to include several acts, forms of conduct or behavior, item A requires further clarification. Additionally, items A to E contain the term of a sexual nature. However, the bill does not define that term. So essentially, there are examples of the different types, but there is no specific definition. Also in Clause 2, the term sexual harassment, the recommendation is that the word unreasonably should be removed from subclause 1, which reads, interfering unreasonably with the work performance of the person to whom the sexual advance is made, as it could give rise to a defense if the interference was reasonable. The bill also in Clause 34, the bill does not expressly seek to cover disclosure made in the public domain. Neither does it state whether it falls under other sub judice rule.
Just for clarity, based on your presentation, you're moving to 34.
34, yes.
Are you going to treat with 29B as you have indicated?
Okay, that was a grammatical error, right? So, based on the document, Clause 29B, it was recommended that it be amended as follows: shall take instead of shall lake. And also clause 31, section 3, the full stop should be removed after the word may. Moving back to clause 34B, section 2, the Act does not outline the basis by which damages arising from sexual harassment will be assessed. Clauses 34.4, 37.3b, 38.2, and 39.2, all the offenses throughout the bill seem to have the same weighting. That's the same level of seriousness and the same penalty. The offenses, however, are different and may have different levels of seriousness. The penalty should therefore be adjusted accordingly. Clause 38 also requires further clarification. In Clause 38A, Section 3, thereat, which is one word, should be separated to two words, there and at. That is basically the end of the presentation.
Thank you. Comments, members?
Chairman, I'm seeking some clarification at 34, clause 34. I don't think I fully understand the comment that you have here when you says that it does not expressly seek to cover disclosure made in public domain. Perhaps you could just elaborate a little for my understanding, please. Thanks.
34.
34, just 34.
Clause
yes,
34. Just a second, I'll ask my colleague to assist.
When we were deliberating that clause, it was raised in our discussions that if the disclosure was made through the internet, on the internet, or some other public means, because it talks about declaration that the respondents had engaged in a conduct amounting to contravention under this act in a manner in the declaration and shall not repeat or continue to conduct. Dismiss the so okay, so we wanted to find out if there was a report already made or it was publicized by way of social media that was not taken into consideration in this clause.
I think that what we are grappling with is because it is the section deals with the award of the tribunal, so that the tribunal has many factors which it can take into account in determining what the outcome will be. And I'm not sure, I just want to really understand, I'm not sure that that would be a place, the appropriate place to speak to that, because what you seem to be doing more is to be raising something, an offense in particular, rather than a matter which we would deal with under 34. And I think that's what we want some clarity about.
Member Morrison?
Yes, or is it that or are we to understand then that within the context of social media that you're talking about, the concern that you're raising, that this issue, whatever it is that the tribunal may rule on, you are concerned that the part that says contravention under this act, right, the issue of social media and how we deal with it is not fully encapsulated here. Is that the thinking?
That was my recollection from the discussions, yes.
No, what I asked is, here, when you look at it, 34B1, it's saying that a declaration that the respondent has engaged in conduct amounting to a contravention under this act, right? The member is contending that under this act, what may play out on social media is not adequately captured, and how such a thing may impact the individual. So it suggesting, of course, that this thing may be wide. That, right? So and the tribunal therefore may not be able to adequately.
But if that is a concern, I don't know if 34.2 gives any assistance, because 34.2 says that the tribunal may, in making an award under subsection 1, take into consideration injury to the complainant, feeding or humiliation suffered by the complainant. Right. And to my own view, therefore, is that issues such as that raised by you would be one of the factors that the tribunal would likely take into consideration in determining the kind of award or the amount of award that is given.
I think what we considered that this was a modern piece of legislation, and we wanted to see something reflected. I understand that it does not limit the tribunal from taking into consideration such issues, but just in discussions arising from the ministry, those are things that were pointed out when we went through the legislation.
Chair, I'm trying to understand, and my interpretation as to what is being suggested by the ministry, and I could be wrong, is that the manner in which it's disclosed can come in many formats. So a complainant might raise a concern to the employer, but the concern could have been raised by others in the public domain. And as you have indicated, social media. So it's a question as to how the disclosure was made. And is it that you want to ensure that we must take into consideration the various means to which that disclosure could have been made?
Member Gale. Hi.
Sorry. I'm not used to your voices.
Yes, Senator Morrison.
Yes, my colleague Fraser Binns, we were just going through this particular consideration, and we're wondering if this would now be resolved regarding the piece of legislation having to do with cybercrime. All right, remember, it's one thing to be at work, right, and you say things to me within the workplace that's inappropriate, and I may consider it to be sexual harassment on location. But it's a different thing when you may take to social media and post up some things about me. What provision is there in the piece of legislation that would add a particular punch to that component? As you have mentioned, it's a modern piece of legislation that we're crafting, yes? And we ought to take into consideration that you may have a co-worker who may take and even apart from co-worker within the workplace, who may choose to harass you or abuse you via the social media platform. So I don't know, I am hoping that we are articulating your concern very well.
But fully though, I don't believe this is the appropriate place, the appropriate legislation to deal with such a matter. There has been, if you'll recall, there was a person from the United States who brought an action against a Jamaican under the Cybercrimes Act, and she was lauding the legislation that allowed her to have her concerns addressed. Now, I think that what we have to do is look at this scheme that we are establishing, and I think what it seeks to do, even if you look at the sort of policy statement which the legislation requires, it deals to the harassment in the workplace. My respectful view is that if you put it out there in cyberland, you have taken it outside of the workplace, and that there is adequate legislation that we could use to deal with that. But that is my view. I don't know if Mr. Bailey would or anybody else would share.
Chair, when I look at the definition of sexual harassment on page 3, it doesn't exclude. It doesn't, because it speaks to the making of any unwelcome sexual advance towards a person by another person, which is regarded as being offensive and has the effects of doing these particular things. If it happens that that information is sent to you via the internet, I think that this definition will cover. It would include that sort of a.
I think that the person making the submission actually wants it to specify. Because if you look at the section where she has brought it up in relation to the award, and what she's actually, if I understand, saying it's almost an aggravating circumstance. That is the thrust of her submission.
Found, where the tribunal finds in favor, a declaration is made which speaks to the contravention and the manner in which it took place, and there should be there's something issued to say that the person shall not repeat or continue the conduct. So I still don't think that it excludes what there is and what Ministry of Tourism is raising respectfully.
Chair, I think the tourism sector is making their presentation now, right? Yes. I was a bit late, Chair, so I just wondered, have we dealt with the whole question of visitor harassment or generally harassment in the tourism sector? And from your checking on this legislation, is this going to assist us at all in the tourism sector?
No, we have not, the legislation, when we read it, we did not see that it went into harassment in the tourism sector.
But you will agree, though, that some of it pertains to the...
If it's in a workplace setting, so if the employer and employee relationship in the hotel sector, but a visitor, as against a visitor and an employee of the hotel sector.
Could you help us? I mean, you're more familiar with some of the harassment that takes place in the hotel sector. Is there any way we can help you to not necessarily highlight, but at least let our overseas agencies recognize that we are responding to a lot of the concerns that have been expressed? I mean, maybe you could help us there.
We would have to liaise with some of our entities or other entities and seek clarification from them and get back to the committee with those suggestions.
I know, but I hear regularly about harassment And in all sincerity, to the best of my knowledge, it goes both ways. The visitors harass the poor young girls and men too in the tourism sector. But to the extent that, I mean, they may be harassed, I'm not talking about criminal conduct, because criminal conduct is straight court case.
Right.
But to the extent that unnecessary, uncomfortable harassment take place, is that prevalent in the tour? Is there lots of complaints to the tourist board or to the whoever?
Remember, that's why I said that I would need clarification from those entities. So the tourist board and TPDCO would have that information.
But
Because
no, I know we can't address totally
right.
everything, but to the extent we at least say that in this preliminary or first act, it covers. I mean, what would be nice, to give you a good example, is should we put that at the business place, be it supermarket, be it the hotels, something like sexual harassment is prohibited in this business place, and it involves ABC. Things like that would at least give the impression or the indication that we are responding to allegations of these things happening, because you hear it all the time. And I mean, as you know, a lot of, big write-up about harassment in the tourism sector, and the impression is given that we are doing nothing about it.
Mr. Sains, members, persons, technical persons here, I must apologize for being late, but Senator Cavankeel took over, and I want to thank him for doing so. I'm also sorry, Mr. Sains, that I missed your presentation, but I do have the details here in writing. And just a follow-up to Minister Chuck's question. I just want for clarification, has there been any indication from the Ministry of Tourism to the tourism sector about developing sexual harassment policy within the sector, and issues of sexual harassment that have been raised in the past, and even in the case where action has been taken overseas by guests? As a result of those things, is there any kind of protocol or position taken by the Ministry of Tourism and conveyed to the sector? And secondly, has the sector or the ministry reached out to the Bureau of Gender Affairs that assist government entities and private sector to develop sexual harassment policy?
Good afternoon. Again, I am aware that there has been at least one sensitization session, but it is work in progress. So if my memory serves me correctly, it was held at TPDCO, and you also had constituents from outside of Kingston who participated in that exercise. But in terms of having a physical policy, we have a lot of work to be done where that is concerned.
All right, thank you. Well, I think in light of this legislation and what it's intended to do, that I would ask that the Ministry of Tourism, that you reach out to the Bureau of Gender Affairs and to develop some kind of protocol and get guidelines in developing a policy that would also be conveyed to the sector. Because we're not only talking about employer, employee, but the issue of sexual harassment, employee with visitors and visitors with employees, a matter that keeps surfacing and resurfacing, and it's a matter that we're going to have to look at to see if it can be addressed in this piece of legislation or we have to address it otherwise. But I think it's something that, and I'd love to get comments on this
Chair,
area. Please,
Chair,
Senator Gale.
being a representative of workers in the industry, we have come across situations where the harassment of a sexual nature can be viewed as, in some instances, rampant, where the employee will harass the guest. The guest will harass the employee because there is an expectation that you come here for not only sun, sea, and sun. And you have situations also where the employer harass the employee. And because of the precarious nature of employment in the industry, one of contract employment, we find that some of the reports that reaches us are where you have, at the expiration of a contract, there's a certain expectations of delivery by some employees. And so these are some of the things that have been reported not only to the employer, not only to the HR management, but to the representative of the workers. And the critical thing about this piece of legislation is that it dictates that organizations must establish a policy, and the policy ought to be known by the employees, and the manner in which you treat with the grievance of any nature or the report of any nature must be explicit. But we may want to go further than that, since tourism is a mass employment industry, and this is where you may have a number of cases presented. Maybe we really want to look at a policy for the industry itself, because some of these hoteliers who are multinationals, they don't want to take it on themselves to define certain policies unless instructed to do so. Unless instructed to do so. So that might be an area that we want to look at. But it would be very good and very helpful if the ministry could give us some sort of a feedback in terms of, conducting your surveys or gathering the data from the respective agencies, the JTB and the TPDCO, for us to have a helpful feedback in guiding the process.
Thank you, Senator Gale. That's very important.
Just a last point, Chairman. 'Cause what the tourism representatives are saying is that they need to go and consult with, their different agencies. But it seemed to me that the tourism ministry has to be proactive. This is a live issue because it has come out on a number of occasions. And it's very important that at least we have some directive or policy to be adopted by the various tourism hotels, whether it is putting up signs or whether it is sensitization of the employees, how they deal with guests who either harass them or to emphasize that they must not engage in it with guests, because you don't want a situation where Jamaica is seen as a place where sexual harassment is predominant. And, that is one of the negatives, because in developing the tourism industry, which is going by leaps and bounds, quite, very good, we don't want any sort of negative to really affect the industry. So I would hope, Minister, that with this outline, the various agencies can say what more would be needed for the tourism sector.
Yes, it really is an important issue, and there is some urgency, because I've had persons from the tourism industry calling me saying that they have been approached by overseas media about sexual harassment and that they have indicated to the media that we are looking at a sexual harassment legislation which will address that, but it is really not directly addressed in this piece of legislation. It only treats with employer-employee. It treats with landlord-tenant. Do not know if the tourist would be regarded as a tenant, a visitor, you stay in the property. I don't know. But I think this is something that we need to look at and to see how we can address it, because it's going to come again. It's going to come up again.
Chairman, you may recall last week that we spent a considerable time discussing this very same issue, albeit not related to the tourism industry per se, the tourism sector, but just generally, and we use the example of the cashier or the waitress, and how someone who comes on, assaults that person or sexually harasses that person, and how to treat it. And I think we accepted the recommendation that we may need to review the legislation to ensure that specific provision is put in place in the legislation to ensure it covers situations like that. And listening to the discussion, I'm even more convicted now that we must indeed have such a specific legislation dealing with that particular type of relationship, which is not yet dealt with.
Minister.
Go ahead, MP.
I just wanted to just add, because as Senator Fraser-Binns said last week, we actually spent some time on it. But since you asked to hear the views, I am hoping that the bill will definitely include those other kinds of relationships of which we spoke the last time. Your client, employee, client, and especially as it relates to the tourism industry. Often when we talk about it, we kind of look at it that we want to protect Jamaica's reputation. And I understand that, so I'm not knocking that. That is something for us to look at. But I also believe that we need to ensure that our workers are thoroughly protected in the tourist industry. And I'm not sure, we spoke about getting from the agencies, and I'm not sure if the comments and opinions we get from the agency also takes into account fully the experience of workers and what they would like to say to us, if you understand the point I'm making. Because I'm thinking, well, not that I'm thinking, I know I've spoken to enough individuals who work in the industry who will say to you that they have to find ways of dealing with harassment and they can't put it on the books, or they can't come up and talk to their employers because for fear of losing their job, and also because of just how prevalent it is. And so I'm thinking that we need to find a way to ensure that we are clear from those individuals hearing those stories and those voices, so we're clear as to what we need to do from that perspective as well.
Thank you, Member Brownberg. I would like to invite one of our attorneys here, representatives from the agencies that are here, to give us guidance and support if you would have an input to make in the question of sexual harassment as it would impact on the tourism industry, and the fact that it's not addressed in this piece of legislation, and any ideas, any thoughts that you would want to put on the table.
First of all, Chair, this legislation deals with civil liability. So there is no criminal offense of sexual harassment. So I'm still grappling with how we would deal with it in the tourism industry. How are we going to enforce it if we intend to keep it as a civil liability piece of legislation? Because remember, there's a very thin line in some instances between sexual harassment and sexual assault. And sexual assault. Yes, and sexual assault is an offense, a criminal offense under our law. So we will have to, seek further guidance on that issue. The other thing is, I remember when this bill was being the policy was being developed, it was developed specifically to deal with exactly what is here in the workplace and employer and employees situation. So it will have to be, if we are going that route, it will definitely have to, we'll have to definitely expand the policy that was adopted and approved in this legislation.
Since this bill was developed, you know, we have had issues of sexual harassment. I don't know if Mr. Bailey has a comment. I'd just love to hear your comments and get your input.
Thank you, Chair. I feel appreciated. I agree with my colleague from Parliamentary Council. I think that what has been said by the members in relation to having some provision for third-party harassment, that is harassment by guests, customers, and the like, would go a far way in assisting with this. But on the other side, because in fact it would emphasize the responsibility of the employer to protect the employees where that is concerned. As it stands now, where an employee may be harassing a guest, I do believe that that would fall under the usual employment law and practices and would be a breach of the terms of employment of that worker. And I understand from the press and that several workers have lost their jobs for doing engaged like that kind of behavior. One comment that I think might be helpful for the Ministry of Tourism, though, particularly where the hotel is part of a chain as a multinational entity, if they operate in anywhere within the European Union or North America, they will, and I think internationally anyway, they will have to have had policies in relation to sexual harassment, and perhaps what needs to be enforced and made sensitized for the management and the employees is what those policies are, and where they fall short of what is required under our legislation, that they be adjusted to accommodate it. But they should already have in their normal work and in their normal business would have policies in relation to that. And so I think that could be a good starting point for that. One of the final comments from me is that considering this is an industry that would have specific problems, I would think it would be in their own interest to put together a code of practice rather than waiting for legislation or whatever to be imposed on them. This act does provide for the making of regulations, for example, and it is conceivable that regulations could be made that could govern apply to a particular sector. But it would be in the interest of the industry to take the lead rather than wait for the government to do something.
Thank you. Thank you, Mr. Bailey. Yes, Mrs. Brownberg.
I wanted to just agree with what Mr. Bailey was saying, but just to add that even in those cases where the sector would find it in their interest to establish policies and practices, I would also see the actual employee often not being properly covered or defended. And so because of that, as you had said, I think it is important for us to look at what you call it, third-party harassment, as you put it. And I certainly would like to encourage the minister to look at the policy that is to guide what we're doing so that it becomes part of the remit as far as looking at the provisions in the bill would be concerned.
Thank you, Mrs. Brownberg. Senator Gale?
Chair, you see, as we go through this piece of legislation that is sensitive in nature, a lot of things are going to come at us. Last week, there was a representation about catcall and harassment outside of the domain that is defined under the term institutions. And as we progress in these discussions, we have to make a determination as to the scope and objectives of the bill. Because as it is now, the jurisdiction that is treating with this bill is the tribunal. There are other offenses of a sexual nature that belongs in the court. And we have to determine how far we want to stretch this piece of legislation or expand the protection into other areas. But something just jumped out at me in terms of we have the definition of sexual harassment. But I don't know, and the legal team might be able to guide us whether or not the code or the regulations might expressively state the types of harassment, so that when the evidence is put forward before a tribunal, that evidence will depict the type that is used, because it's not so defined here. And I remember last week also I extended the need to define workplace, because workplace is not defined. Worker is defined, but workplace was not defined. And so as we progress, these things are going to come up, but we have to determine how far we want to expand this piece of legislation. Do we want to go so far? Do we want to have parallel type of jurisdictions in means the tribunals or the court, which would make it somewhat cumbersome in nature? So those are my initial concerns.
Thank you, Senator Gale. Please go ahead.
Just to say to Senator Gale that the definition of sexual harassment speaks of unwelcome sexual advances, and sexual advances defined above. Maybe we need to expand it, or maybe we need to, simplify the circumstances, but it is linked. So I don't think there will be any need to state what's it. Yes.
Advance to include others.
Chairman, just for clarity, so, and maybe it's because it's something that I feel strongly about. I want to make sure that what I am proposing, I'm looking at sexual harassment as it is defined here, and I'm not sure if I am sensing a concern about sexual assault or harassment, action that moves from harassment into another area, which would then move us out of, move into criminal liability. But what bothers me is that I hope that the fact that we are fearful that it might means that there is a problem to be addressed. And it is not that we should be afraid of dealing with issues of sexual harassment in a particular area for fear that we might not really be dealing with harassment, but we might be dealing with assault. Because as legislators, we must make provisions to protect our people. And I mean, that at the end of the day is what we're looking at. So the other sexual assault and so on might fall outside of the ambit of this particular bill. But it shouldn't make us be fearful of including it, because we might be going for harassment, but oh my gosh, it's not just harassment we're talking about, it's assault, so what do we do with it? Because the idea is to ensure that we prevent those as well.
Thank you, Mrs. Brown. But Mr. Whittle?
Yes, I think that might create some kind of a conflict. I think maybe where we could look is to, given the fact that there will be a tribunal that you would refer these matters to, then that could be the point of determination whether it is to be sent further as a criminal offense or not. The tribunal should be able to make that determination. So I think we could empower the tribunal with that kind of a responsibility to say, well, this, what I have here in front of me, is for the courts. Yeah.
Thank you. Well, I think we have aired this sufficiently. I don't think this will be the end of this discussion. But I just want to thank representatives from the Ministry of Tourism for their presentation, and to indicate to you that I think we would want to hear from you again, coming out of the discussions we had here in relation to your position on sexual harassment as a sector. I will now ask Women's Empowerment for Change, We Change, for you to make your presentation. We have with us Shante Portius and Christina Neal. Please go ahead.
Madam Chair, members of this committee, fellow presenters and onlookers, good afternoon. We are here today representing Women's Empowerment for Change, We Change, which is a women-led women's rights organization committed to increasing the participation of lesbian, bisexual, queer, and ally women in social justice advocacy. Our advocacy, actions, and projects are aimed at bringing attention to societal issues that impact the quality of life of all women across Jamaica, as well as educating women on their fundamental rights and equipping them with the tools and information needed to advocate within their own spaces. If we may, we would like to present to this House a few... No problem. Is that better?
You want to use both mics? Turn the other one on and point
Can you
it
hear me
in
now?
the direction.
Much better?
Right,
Okay.
and speak up so your presentation can be...
Okay, wait, chair can move. The chair's heavy.
Can be and if you could just slow down. We're not rushing you, okay?
No, it's not. No, I've been wrong one. Okay, there. Next. If we may, we would like to present to this House a few short stories before we commence with our recommendations. Our first story begins. I remember one morning walking along the sidewalk in Halfway Tree, St. Andrew, minding my own business when a man riding on a bicycle reached out his hand and grabbed my breast, then rode off. In another instance, one woman shares, I was walking towards Halfway Tree from work. Several men were calling to me, but I ignored them and proceeded on my route. They caught up with me. One said hello. I ignored him and continued on. A couple minutes later, I had turned off the route. I looked around and noticed they were still driving behind me, slowly, a few cars away. One man shouted, "You feel we do? You know so we're there." I made another turn, and they turned as well, commenting that if you did answer we would have given a ride. I quickly picked up the pace towards Winchester Road and turned onto the next road before I was able to lose them. I was terrified, completely terrified.
Radio broadcaster Dionne Jackson Miller, on her program Beyond the Headlines, produced a docuseries on catcalling in Jamaica in 2019. Here are a few tweets shared online. Driving home at 2 a.m. and got pulled over by police. As I handed him my license, he grabs my hand and starts feeling it, talking about how my hands don't look like I do housework and asking for my number. Another story. Walking with my uncle past Pablo's in my school uniform, and a man grabbed my arm and tried pulling me towards him with the usual "Wagwan babes." I was 13. Another story. I was dressed in a hoodie and pants walking through Mandeville, and the male vendors kept calling me sodomite. When I was at UWI, my wardrobe was fitted caps, t-shirts, sweats, and sneakers, and I got abused by taxi men every day. Anecdotal as these stories are, due to the absence of research and data on street harassment in Jamaica and the wider Caribbean, they reflect a shared experience that most, if not all, Jamaican women endure as an unwarranted and undesired rite of passage from the first sign of puberty. In one of the largest studies ever conducted on street harassment, Cornell University and Hollaback International discovered that the majority of women across the world are street harassed before the age of 17. For a bit of specificity, 95% of women in Argentina and 81.7% of European women. Can you imagine the local statistics? The onus to address sexual harassment has always fallen on women. The narrative surrounding the issue is deeply entrenched in Jamaica's rape culture, which facilitates the harassment of women without legal reprimand. When these issues are brought to the forefront of conversations, we're met with the assumption that women are their own harbingers of harassment. We allude to her dress, question her presence in the location, and require her to explain how she could have allowed this to happen. In order to adequately serve women who are equal citizens, we are in dire need of legislation which will then inform policies that protect women across different spheres. Here are our proposed amendments and recommendations.
Recommendation 1, inclusion of street harassment in the Act. Our current Sexual Harassment Act pays heavy attention to sexual harassment in the workplace. While necessary, our Act must also reflect the cultural context in which it operates and subsequently provide the requisite protection and guidance on how to enact a needed shift in this society's paradigm of the treatment of women. We change, therefore, echoes the sentiments of our colleagues at last week's hearing to include street harassment in this legislation's definition of sexual harassment, where street is an umbrella term for public spaces, which would include transportation, stores, and roadways. The Act in its current state elucidates the inappropriateness of sexual harassment within the confines of a workplace and institutions, the process and mechanisms for seeking redress, and the duty bearers with responsibility to respond to offenses. But what of our lives outside of these particular confines? As illustrated in the anecdotes at the start of this presentation, sexual harassment for a majority of Jamaican women is prevalent in public spaces. There remains a void in the legislation that allows for accountability within these spaces, which inevitably ignores the scores of people who are victims of sexual harassment who exist outside of the parameters defined by law. We understand the difficulty in creating legislation that addresses every possible instance of harassment. However, as legislators, you must strive to design an act that is comprehensive and in keeping with the realities of those it seeks to govern. Further south, the Chilean government in 2019 passed a law that has made street sexual harassment a punishable crime with fines and prison terms after recognizing its impact on the lives of women and girls based on research provided by the Observatory Against Harassment in Chile, 2015. On the same continent, Peru recently reformed their sexual harassment legislation by first recognizing sexual harassment as a form of violence, expanding its definition to include behaviors of a sexist nature, as well as criminalizes groping and physical contact in public spaces once done through threat or violence. Buenos Aires, Argentina, in 2016, moved to criminalize catcalling with a fine of 1,000 pesos. Their law reform has outlawed direct or indirect comments referring to a person's body and non-consensual physical contact, indecent exposure, public masturbation, and pursuing and cornering. And it will embark on public education campaigns to sensitize the public on sexual harassment's dangerous impact. On that note, the Economic Commission for Latin America and the Caribbean in 2019 initiated a public education campaign in Trinidad and Tobago aimed at exposing street harassment as a form of violence against women in the hopes of reducing its prevalence. We recommend that this committee look to the above-mentioned countries for guidance on how to specifically outlaw and criminalize street harassment.
Recommendation 2. The Act must explicitly state how to treat with harassment by a third party. A third party can be persons who interact with institutions and businesses, such as vendors, clients, and business partners. In an increasingly digital world where freelancers are becoming a part of the labor force and non-traditional and working setups and dynamics are being created, our legislation has to graduate to accompany this rapid change. Additionally, while we are cognizant of the Cybercrimes Act of 2015 and its stipulations, the Act does not make specific references to harassment and further cyber harassment in a working relationship. Can the committee provide clarification on whether Section 2, where it defines worker in subsection C, covers this kind of work arrangement, that is short-term workers or consultants? If not, how will the law treat with these kinds of work dynamics? We need to consider sexual harassment outside of the colleague-supervisor relationship that the present act mentions. Employees will have to work closely with clients, customers, and partners in and outside the physical workplace. A workplace sexual harassment policy should reflect this and should make sure the reporting channels are known by all staff members. Having regular sexual harassment training with staff members and HR personnel will reassure employees that they should feel comfortable making a complaint about harassment by a third party. Employers can also disseminate the information periodically via their internal communications channel. Statements about not tolerating abuse and harassment of staff should be visibly displayed using clear language so third parties can understand what action the employer will take if they breach it. We urge this committee to move swiftly to include a definition in Section 2 that clearly states who may be classified as a harasser. This definition would include third parties. One such definition used by the U.S. Equal Employment Opportunity Commission says, the harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or customer.
Recommendation number 3. The state must design a sexual harassment workplace policy guide or template and mandate that all businesses and institutions utilize this guide to design their policies. A major issue that has prevented adequate redress for sexual harassment and its eventual elimination in the workplace is understanding what behaviors constitute harassment within the workplace, and as such, businesses should be mandated by the government to have a policy in place for workers to reference. The International Labour Organization has sampled sexual harassment policies and several code of conduct and guidelines to prevent and address sexual harassment in the workplace that can be enlisted to aid in the creation of a template. While these guides are country-specific, the content of the guides can be easily translated to the Jamaican context. It is necessary that the government leads the charge in what a comprehensive sexual harassment policy for the workplace looks like, as it will ensure that these policies are harmonious across the board and align with existing legislation. In his research, Sexual Harassment and Sexual Harassment Policy in Jamaica, the absence of a national sexual harassment policy and the way forward, Paul Bourne found several themes, 2 of which spoke to the role of culture on policy and the perception of harassment. The research highlighted that due to the lack of a clear definition of harassment, there is difficulty in implementing frameworks that address the issue. The study also highlighted that in Jamaica's social context, sexual harassment is difficult to identify because of societal attitude towards women and women's bodies. In its summary, the research postulates that policies surrounding sexual harassment are not effective as a deterrent, but rather serve as a backup in the eventuality that sexual harassment occurs. In an aim to address sexual harassment, the Equal Opportunity Commission of Trinidad and Tobago created the Guidelines on Sexual Harassment in the Workplace publication in 2018, which serves as a guidebook for employers. The publication dedicates an entire section to mechanisms to prevent sexual harassment and mechanisms that respond to cases of sexual harassment, which includes grievance procedures, procedures to solve complaints, disciplinary action, and protective and remedial action. This publication promotes the use of mechanisms such as communication, training, education, commitment, and dissemination of information as the means to introducing and enforcing sexual harassment within the workplace.
Our 4th and final recommendation, consider the inclusion of a section that speaks to stalking with an online sexual harassment component that complements but is separate from the Cybercrimes Act. Stalking has become more widespread in our culture, and many Jamaicans don't know what to do in the event that they're being stalked. We can recall a situation where a woman on a popular social media site detailed being stalked by a man for over a period of time. When she went to the authorities to express her concerns and her need for protection, the authorities told her that they were uncertain of what to do. We urge the committee to include a section in the Sexual Harassment Act that defines stalking and outlines actions to be taken if one believes they are being stalked. Additionally, we suggest that there also be included in the bill a category that speaks to cyber or online harassment. According to an EU-wide survey examining violence against women, 11% of women have received unwanted, offensive, sexually explicit emails or SMS messages or offending inappropriate advances on social networking sites, referring to experiences since the age of 15. In Section 2 of the Act, while there is mention of a statement being made orally or in writing, there needs to be explicit references which identify the use of technology as a medium for sending unrequested pornographic, sexually suggestive, or unwanted lewd material, whether graphic or written. The European Institute for Gender Equality establishes that 1 in 10 women have already experienced a form of cyber violence since the age of 15. In their assessment, cyber harassment can take many forms, including, but not limited to, unwanted sexually explicit emails, text or online messages, inappropriate or offensive advances on social networking websites or internet chat rooms, threats of physical and or sexual violence by email, text or online messages, hate speech, meaning language that denigrates, insults, threatens, or targets an individual based on her identity, her gender identity, and other traits such as sexual orientation or disability. Article 8 of the European Convention on Human Rights protects personal information that individuals justifiably expect not to be published without their consent. Legislation needs to represent that reality of this social landscape by including in our legal framework laws that consider online presence and use of online spaces and electronic communication. We provide protection across a myriad of spaces. In conclusion, it is time that Jamaica upgrades its current legislation to reflect the changing realities of its society. We urge this committee to include robust data collection after the act is passed to determine the prevalence and nature of sexual harassment in an effort to evaluate the measures presented and an action plan to respond to the findings. Let's hold successive governments accountable to ensure the act serves the people. Your responsibility as legislators, which you are acknowledging by being here today, is to respond to the needs of your population, the people you promise to serve. Sexual harassment in Jamaica is as common as the cold. This does not mean we accept it as inevitable. This does not mean that we cannot engage in action to create deliberate cultural change. This does not mean that women have to learn to navigate a culture that is toxic and which forces them to navigate their daily lives in fear. We must ensure we are taking precautions to remove this stain from our culture if we intend to follow through on our 2030 vision of making Jamaica the place of choice to live, work, and raise families. I encourage you to not be a house with only beautiful speaking, but to let our actions walk before us. We thank you.
Thank you. Thank you, ladies, Ms. Portius and Ms. Neal. Thank you. I invite comments. Mrs. Brownberg.
Clarification. You made sorry. No, I will yield.
No. I wanted to go back to the issue of street harassment. Again, it was an issue that came up last week as well. And I have heard a number of individuals suggesting that because we are not agreed or think it is difficult to identify and process and then determine the course of action, that it should be left out. And I don't know, I'm thinking that we must also be guided by the percentage of harassment and where they take place. And if, as the data is suggesting, that a lot of, many women are harassed on the street, that in terms of sexual harassment, that is one of the sites where it is prevalent. I do not believe that we can pretend it does not exist. And I do not believe that we can turn a blind eye and do nothing about it. And so if we are being as courageous, having a sexual harassment bill in 2020 is not really courageous, but if we are going there, then we also have to be courageous. And we cannot simply say, let us not go there because it is thorny, because it is difficult. We are required to look at the data and to look at how we protect our women and our men and our citizens. Let's call it that. How we protect our citizens. And I really believe, I said it last time and I'm repeating it again, that I think it is something that we should not ignore. Granted, in the policy guideline, it is not part of that. But elsewhere, we have never been afraid to say the policy doesn't deal with that. Can those with the authority look at that to guide us? And we have never been afraid in other committees to say it doesn't deal with that now, but maybe it should.
Thank you. Senator Gale? And then.
So, if we define who can be harassed or where the harassment can take place, I believe you made reference to a definition of the harasser. So if we are going to protect those who are harassed, we may have to define the harasser. I don't know if you want to just highlight the definition that you had.
Not a problem, if I can find it. Found it? Okay. So this definition, we pulled it from the U.S. Equality Employment Opportunity Commission, and it says that the harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or customer. So this one was specific to the employer-employee relationship, as well as the mention of third parties. So we believe that in having this definition, it makes it a little bit easier to chart our course in terms of how we treat with third-party harassment. I hope that was clear.
Yeah, Mrs. Brown, Celia Brown.
By virtue of clause 3 of the bill, Chair, I think the only one that we haven't dealt with is the third parties. Because we speak of the supervisor, the employee, and the co-worker. Is it 3 or? Yes. In clause, sorry, I think I have the wrong clause. Right, sorry, it's clause 7. Clause 7. In part 3, forms of sexual harassment and related prohibited conduct. So I think the only one we haven't dealt with in the legislation is the third party. Yes, in the workplace, which I think we...
To client, though.
But that would be third party. Yes. That's the only one.
Mrs. Scott Motley, you were going to make a comment.
I was simply, Minister, endorsing what Member Brownberg said, that we can't be confined in our deliberations to what is actually here, because I listened to that series that Dion Jackson Miller did, and it was painful. Very painful. And I think we have to be cognizant of what young women and women generally are enduring in the society. So if it might delay us a bit, but I do think it's of great moment, and it's important that we consider it very carefully. I was just supporting her, Minister.
Well, that's the purpose of the Joint Select Committee, for us to receive presentations and for us to consider what's being put in front of us. Yes, Mrs. Celia Brown. I'll come back to you, Senator. Yeah.
In relation to what Member Scott Motley said, some of these, what was said by the presenter, a lot of these conduct, a lot of this type of conduct is covered in our Sexual Offences Act. We have the offense of indecent assault. So that's the thing. I'm still grappling in my mind with where do we draw the line between sexual harassment in its civil capacity, and if we intend to include street harassment, which will obviously have to attach some sort of criminal liability. How do we do that in light of some of the offenses that we have in our Sexual Offences Act?
I appreciate the problem, even in relation to the discourse we were having about tourism harassment. You know, sometimes it's fleeting. Sometimes the person can't identify the person who has been a harasser. But I think there is a way in which we can navigate that kind of process. Certainly in relation to the criminal aspects under the Sexual Offences Act and this, one of the things that we have to contemplate is how the court system works and whether it might not be more prudent to have it in this legislation, which would take it out of the court system and put it before the tribunal. They're challenging aspects, but I know that we are up to making a decision on these matters.
I would tend to agree with Mrs. Scott-Motley that we need to explore. We need to look at it. Senator Gale?
You see, Chair, the harassment in the public domain is a pandemic. Women go through it every day. And in the scope of this bill again, the question is we have to find a way to get what are civil matters before a tribunal and the scope of the tribunal, because a tribunal is going to be totally overburdened in treating with these matters. So we have to think about how we expand the role and function of the tribunal. And when you treat with what is in the public domain, the investigative method in treating with it, because it's all good and well in the institutions and the workplace, there might be established procedures to lodge the complaint and to deal with the complaint even before it gets to the tribunal. But how do you treat with those in the public domain? And that is what this committee is going to have to consider. Now, one of the other things that came out in the presentation was, in my mind, what are those other harassing mediums that are not physical in nature but more nonverbal? And under sexual advances definition E, any other physical, gestural, verbal, nonverbal, or visual conduct of a sexual nature might be the closest way to treating with it. But, in this day and age of digitalization, and where you are treating with customers, and I've had in the service sector, those employees who have to treat with customers and customers who have their information would have received advances bordering vulgarity that they have to treat with. And so when they make the report, the evidence have to be taken into consideration. So we may have to explicitly outline some of these areas that you spoke about so that the people will have a case. Yeah. And the tribunal would find merit, because in those who are these third-party clients now, they will have good lawyers who can defend them. And I know lawyers are here, but many, right? But it's a question of the procedure, how they are going to be represented, and how the tribunal in 34 will make an award.
Thank you. Go ahead, Ms. Grant.
Madam Chair, I just wanted to make the point In the presentation, I think it was recommendation 3 that spoke to the policy guide. Currently, the bill in 4 speaks to the policy statement. The point was made that it needs to be clearly outlined what is to come in the policy guide. But as we have it here, the policy statement, there are elements that the policy statement must include. I don't know if we change, if they're saying that it needs to be expanded, what is already here needs to be expanded, or is it that it's something altogether? I wanted clarity on that.
You need them to clarify, please do.
I'm sorry, can you repeat your question?
You spoke to the policy statement, that there should be a policy statement that mandates all businesses and institutions.
Not a policy statement, but a
guide.
Policy, yes.
Right, so I'm saying what is here right now in the bill, it is referred to as a policy statement, and there are certain elements that should constitute the policy statement. That speaks to the internal mechanisms that are at play, the definition of what sexual harassment is, where you go if you are aggrieved, and so on and so forth. So what I want to find out is, would you want an expansion of what currently exists, or something altogether different?
Okay. Well, we are hopeful that when this act passes, that it would have taken into consideration everything that we have presented here, and hopefully expand some of the definitions. But also, one of the main things we wanted to point out is that there are businesses and institutions that don't have a sexual harassment policy that guides their organization. And we believe that the government having a guideline or a template for these businesses to use would be a better way, a better course of action, because then the policy, the sexual harassment policy, would of course be in alignment with what the act says, as well as it would ensure that every business has a harmonious understanding of sexual harassment, instead of allowing businesses to create their own sexual harassment policy, because it can remove or leave out or not identify everything that the act would have identified. So that is the suggestion that we have.
Chair.
Ms. Grant, could you please?
Okay, so you're speaking to a template.
Yes, a template or a guide. So it's either the government creates a template that corporations or businesses can then use, or have an actual guide on sexual harassment in the workplace that would have taken into consideration the new additions to the act.
Okay, well, I just want to point out, I've noted what you have said, and I just want to point out that as it is here, every employer has a duty to issue a policy statement, and the elements that are listed should be one with your policy statement. But I take the point you make about the guide. I know that the Bureau of Gender Affairs is actively involved in helping businesses to have a uniform guide, but we look more into that.
Thank you.
Chair, if I may.
Can we
Senator
have a
Gale?
timeline on that?
Chair?
Mr. Bailey, you certainly don't look like Senator Gale. You're much taller.
Chair, I should advise the committee that, in fact, an earlier version of this bill did, in fact, have what the presenters are speaking of. In fact, I think it's the second submission that has recommended that there be some sort of template. So in an earlier version of this bill, there was actually in the schedule what I would call a default sexual harassment policy, which would apply in the event that the institution or entity did not draft one in accordance with the bill, that this would apply. And it set out what is sexual harassment, who is a victim, who is a harasser, some of the language of which follows some of what was quoted from the U.S. Equal Opportunities Commission. complaints made, the procedure, discipline measures, and so on. And that was actually in a schedule to an earlier draft of this bill. I am not in a position to say why it was not continued into this bill.
Chair.
Thank you, Mr. Bailey. Mrs. Celia Brown?
But Mr. Bailey is saying that the very first draft that was done, you had a template. I can't recall why it was removed in subsequent drafts.
So we need to revisit that.
Yes, yes.
Okay.
Because, Chair, this blue book, yes, this little blue book, the Labor Relations Code, 1976, and it outlined disciplinary procedure. And I was told that when it was developed, they had to, employers and trade unions and the government had to develop that template. Now, when I look at 4.3, 4.3 suggests clearly what the different procedures ought to look like, yeah? In terms of the statement, the internal mechanism, the measures to be taken, the statement by the employer, and it goes right up to the tribunal. But guess what? Once we pass this piece of legislation, institutions and employers are going to say, so what is it that we're going to do? Where is the guide? And that is what, Mr. B, that is a template that would have been missing from this in terms of how are we going to write the procedure to inform the guide or the policy within the organization. And you're quite right, it is going to be needed. And it has to come from somewhere. And I'm suggesting that it must come from the state.
In fact, I know the Bureau of Gender Affairs, they are addressing that, and they're working on that template. But we may need to ensure that it's reflected in the legislation. Yes, that's excellent.
Chair, if I just to follow.
Mr. Bailey,
yes,
and then Mrs. Brownberg.
But just a point of clarity for following from Senator Gale's comment. I think what Ms. Grant, yes, was actually indicating is that subsection 3 provides sets out an obligation on the part of the institutional employer to actually do this, and it sets out what should be included. So they would not be off the hook in terms of drafting a policy. But your point is well made. If it is left to them, then this may or may not happen.
I was just amplifying the point that even though this outlines the mechanism, which is clear, it is very detailed, they are going to say, so where we start from? What is the first thing that we're going to do? Because you must appreciate that it's institutions and employers who do even have the skill set that is going to be required to conform. And so it's not all of them have the skill set within the organization that can develop such a policy and such a guideline. So it has to come from somewhere in the beginning.
Chairman,
Mr. Chuck?
may I suggest that what Senator Gale has said is something the Ministry of Gender Affairs should latch into very quickly. In other words, we don't have to wait till this bill is passed. Quite frankly, when I listen to the presenters, and I know it, women are going through hell. And the taxes everywhere. And I think the Ministry of Gender Affairs should really do some jingles, like they do on TV, on the radio, and really educate our awful men, I might say, that they need to treat our women better. They just take them, take advantage of our women. And quite frankly, as I listen to the ladies and explaining some of these things that happen, which I know, but you have highlighted it well. And I think the Ministry of Gender Affairs should immediately do something, some jingles, so that to see to what extent we can use moral suasion to highlight the problems that women are having, but hopefully to reach some of our real, should I say, miscreants who go about and harass a woman.
We certainly will take that on. Mrs. Brownberg?
Yes, Madam Chair, Mr. Chuck's comments could not be timelier, and it's good to hear it coming from him. And we have a tradition of actually saying we will do public education when the bill is done and really not doing much when it's done. So I like the idea of actually beginning even before, just given the magnitude of the problem, the cultural problem that we have. But I also wanted to just make a request. I think just by trying to follow the presentation, that the actual presentation is much more detailed than what we have. So I'm hoping that it will be circulated. No, man, it is. No, man, I know.
It was sent by email?
Absolutely, yeah, it was sent by email.
You want it to be printed?
No, it was sent by email. Absolutely.
You want it printed?
Thank you.
Sure, sure, we'll do so.
Chair?
Senator Morrison?
Yes, I'm very happy that the call is coming from Minister Chuck, but I also want to strike the balance. I want us to be very fluid when we approach issues concerning sexual harassment, because there are indeed men out there who can tell some stories about women who harass them, right? So many times in this discussion, in these types of discussion, you have women who come across as the victims, and they may very well be. But let us not forget that we also have a culture that tells our boys and our men that, hey, you can't complain about something like this, otherwise you are less than a man. If some of the men in the workplace should show us some of the text messages, some of the emails, and how they are bombarded by women daily, we would be surprised how many men in the workplace, they are either transferred, they are demoted, you have cougars who stalk them, they are treated like boys by women. So I'm advocating that as we continue these discussions, we are very sensitive and very balanced.
Thank you, Senator Morrison. I am aware, as the Minister responsible for gender, that we have to strike a balance. Our women are at a great disadvantage, but we also have to ensure that our men are protected. So the men don't have to worry. I will ensure that they're also protected. We have any further comments? Yes, please go ahead.
I just wanted to respond to Senator Morrison. Yes, I understand the need to strike balance whenever we have these conversations, but I caution us to understand why the focus is usually on women. The data very clearly and explicitly shows that women are disproportionately affected by harassment. It is not to negate the impact that it would have on men, neither is it to negate the institutional and societal norms that have affected men. However, we must contend with the fact that we have a society that has allowed for this sort of violence towards women particularly. So again, I understand that we want to strike the balance, and I do believe that the act in itself is not gender biased. However, we cannot run away from the conversation about it being women being disproportionately affected, and I think that is why. And again, we are a women's organization, so our focus will be on women, but not just that, just the fact that women are the ones who bear this particular burden disproportionately. We have to ensure that our laws, our legislations, our norms, our education, whatever it may be, whatever mechanism and tools that we might use, that we are looking at the people who are victims. And it's not victimizing ourselves, it's just a fact that they are the victims of this sort of violence.
I recognize that, and I think we all do recognize that our women are most affected. and that our men are the main perpetrators. However, we also have to give some attention to how we treat with our men. In fact, we have established 2 helplines, one for men and one for women. And, you know, the calls are welcome from either gender.
Chair, the passage of this bill might create a change in the balance where men start reporting too. But one of the things that I found, especially in some institutions, I came across a particular case where the employee was being harassed for years, and others knew about it and was afraid to speak. And so she suffered in silence because she felt that if she were to report it, then she would have been persecuted. And what we found is that the day she reported it, the manner in which the employer treated with it was to transfer her to a different department rather than investigate and treat with it. And I'm not sure if the legislation can treat with disclosure in the protecting. Maybe it's there, but in terms of how you treat with the disclosure of the information, because there are persons who suffer in silence because of the fear of reporting it. And so there has to be a protective mechanism in place to treat with that. So if it's there, yeah.
Thank you. Mrs. Seeley Brown, do you want to just indicate?
Clause 26 of the bill, Chair, deals with.
Okay, thank you. We have any further comments? Oh, we're doing exceptionally well. Presentations are very precise and well focused, and our comments and responses are very informed. And so I really want to thank you all, and our meetings are not too long. So, yes.
Chair, you made mention of public education, and that can't start too early, as both presenters have mentioned earlier, the need to have our society understanding what is considered as acceptable behaviors. I think we have many of our women and men too who are of the view we don't even, some of us, the lines are blurred, because there have been times when I feel so good when I walk on the road, and depends on what some of these same guys say, you know, maybe I puff my chest out and I actually feel good and I feel hot for that day. Yes, Minister. And I don't know if maybe at that time, probably I was beautifully harassed? I don't know. But the truth is, we have to get to a point where we realize that whether it comes off sounding good today, or at another time when it sounds raunchy or vulgar or unacceptable, you know, we have to teach our population that it is inappropriate. And I think that's a part of what I'm taking away from the presentation.
Thank you, Senator.
We don't like the way you do it, we don't mind.
And right there is.
Thank you. So I think that at this point, we have heard the 2 presentations that were scheduled for today. We did discuss or agree on having weekly committee meetings, but I think I want to suggest at this time, considering that the ceremonial opening of Parliament is scheduled for next week, we have the a number of other committee meetings scheduled otherwise, that at this point, I just want to thank you. Thank you for coming. Thank you for the interest shown and the inputs you have made. Thank the presenters, and to indicate that we would look at when we adjourn this meeting, we will adjourn for a date to be determined. Right, we want to, that's right, and we want to ramp up the advertising of the committee meeting and inviting presentations. So we would want to have a period that we would allow those written presentations to come in, after which we can schedule our meetings and proceed hastily, but certainly in a very detailed way, reviewing the presentations, looking at the legislation, see how quickly we can finalize and take the report back to Parliament. So I really want to thank you all for your input, and to now advise. If there's no other business, I will adjourn this meeting. Meeting adjourned. So moved by Senator Morrison, seconded by Member of Parliament Bromberg. Thank you, ladies and gentlemen. Meeting is adjourned.
Cha la 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 la. Bim. Cha la 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 la. Cause a long time we are rocky Tina down. Me say a long time we are skanky Tina down. Long time we are flashy Tina down. Me say a long time we are skanky.
This is Empress Sativa representing for PBCJ. Boom shakala who make the dancer go peck. Boom shakala who make the people them a rock. Boom shakalak, promote a pocket fat selector, lift it from top on vinyl needle drop. Boom shakalak, them never ready for no clash. Boom shakalak, them chatting one bag of trash. Boom shakalak, promote a pocket fat selector, lift it from top on vinyl needle drop. Special request vital and popular demand. It is the Empress Sativa live, the wrecking at the lawn. Bandy version normally them think a infant in a prom, and the lyrical machine known as a deadly weapon. PBCJ, keep it locked.
Grand Jam Master, turn a young veteran. Wash belly for me, mama, bought me poop a night one. Me a flash a min and nappy baby in a bad man. Originator, feed me style, no copy, be no cop.
Take it down. Reggae music is the heartbeat of the country.
Low and stable inflation
is the heartbeat of the economy.
When I was growing up, violence was the main thing in our community.
When I was in class, I can hear the gunshots, the explosions outside.
I was at home one night, me and my family, and I heard the door kick like 2 times. Like a niece get shot in the house and they shoot it up. I was 12 years old. Lost more than 6 friends through gang violence. The thing I'm most scared of is just losing a family member. Not a normal feeling to see somebody close to you. I take a last breath, huh?